Good morning. The very best act of defending accused who indulge in murder cases. Normally, everybody says advocates are helping the accused to escape from convictions, and they are indulging in antisocial activities by defending them. But practically, that was not the case. We are assisting the court with the given evidence and conducted investigation, and sometimes we say that the offences which was charged is not apt, and we minimize the other bring the evidence to minimize the graveness of the offence, because every chapter of offences have got diminishing sections so far gravity of offences are concerned. So you can, after conducting the trial, if 149 is added, impleading accused who was suddenly a member of the who was just watching with curiosity, we got acquittal from them. Then question of 302, then that has been altered to 304 part 1 by culpable homicide not amounting to murder, and thereafter part 2 culpable homicide amounting to not amounting to murder. Part 2. Part 1 is any act is done with the intention. So that exceptional cases described under 299, you will get conviction under section 304 part 1. There may not be any intention, but you may have knowledge that this act may likely to cause a death of the persons. So it will become part 2. Sometimes what happens, even we get conviction alter from 302 to 326, because there may not be there may be a intentional knowledge to commit grievous act, not to commit murder, or sometimes 323. In one case, I have conducted the murder case before Justice S.T. Ramalingam when he was Principal Session Judge, Chennai, at the time of my commencement of practice. A person who was in inebriated conditions was about to purchase some articles from a petty shop. He was working in opposite side, migrated employee from Kerala. The person who used to collect the columns from that particular export company was questioning about this inebriated condition, deceased, as to how he dare that he is purchasing cigarette in front of him. So thereafter there was some fight between both. Two accused were there, jointly tried to manhandle him. Actually what had happened, he was taken by the co-workers to the upstairs. At the time, one accused seems to have hit him in the stomach. Later on, he became faint. When water was poured on him, he died. So the trial was 302, but conviction was under section 323, because his intention was not to murder him, but only to cause simple hurt by kicking his stomach. Sometimes what happens, if a person after fighting huge and cry became faint, if you pour chill water on his face, there is possibility of neurogenic shock resulting in his death. In that case, the accused may be acquitted. These all are the things. So, to make you understand the clear case of how to bring the offence under section 302 to 304 part 1 or part 2, earlier judgment was about 2008, a clear case wherein the judgment about discussing about Kesar Singh versus State of Haryana, 2008, 5 SEC 753. Now this judgment will help you more area of understanding 302 and 304. This is the AR 2026 Supreme Court 448. AR 2026 Supreme Court 448 Sri Krishna versus State of Madhya Pradesh. Actually, there was a fight between two persons. The father was questioning that resulted both gang indulging in fight each other, and several accused. Counter FIR was also cross FIR, they called it, was also filed by the accused party, because the deceased party assaulted the accused parties also. So the Sri Krishna and other accused were facing charge the 302, 149, 324, 149, section 323 read with 149, and sentenced to imprisonment for life along with other accused 149. And what had happened, High Court has modified this conviction, altering the charges from 302 to 304 part 2. So he was imprisoned for 7 years, High Court, and Supreme Court has reprimanded period already undergone. This was judgment. But the important aspect I would like to take you is at paragraph 4. You see, they have defined how 299 offense of culpable homicide. The culpable homicide is called murder. Culpable homicide not amounting to murder. Two things are there. What is murder? If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death of the persons. The murder is committed if the act is done with the intention of causing bodily injury. Bodily intent to be, so many things are there. They say when act is committed without excuse for incurring risk of causing death, then question arises section 300, some exceptions for murder. Culpable homicide is not murder. The following exception: number 1, if deprived of self-control due to grave and sudden provocation, death of the persons by mistake causing other person or accident. This above exception is subject to following provision: that the provocation is not or voluntary provoke by the offender as an excuse for killing or doing harm to any person. The provocation is not given by anything done in obedience of law. Lawful exercise of right of private defense, whether by grave and sudden enough to prevent offense amounting to murder, is question of fact. These are the answers. Then exception to excess of right of private defense. Then excess of 3 is public servant while discharging his duty excessively behavior. Exception 4, without premeditation, sudden fight in the heat of passion. And the explanation was that who provoked for sudden fight is not the matter. Then finally, the person is died, is aged above 18 years, suffers death or take the risk of death of his own consent. This is what they say is the most important case. Here they say the accused simply assaulted the deceased by lathi. Others were carrying the sharp-edged weapon. One more thing is, the doctor Ashok Kumar has given certificate that there was a fracture of parietal bone and hematoma. Hematoma may be noted by doctor at various places, including skins, shoulders, anywhere when blood oozing out and clotted. But there are two categories of hematoma which will be very dangerous. If hematoma is on brain, it will cause dangers, and hematoma on womb is also causing dangerous. These things are there. Therefore, this section 300 has been clearly discussed. Kindly go through the entirety of judgment and also read Kasser Singh judgment also, so that you can understand and chip out the graveness of offense from higher degree to lower degree. Best wishes.